Okay, so that slide shows up. I'm just on the different monitor then. All right, no big deal. Okay, the categories of our immigration system that we have. We'll start from the bottom and work up. Non-immigrant visas or temporary visa means the same thing. They've got different eligibility criteria, allow for different activities, but everything from visitors to students to a whole host of options that allow for employment. It's kind of, the non-immigrant visas are kind of like an alphabet soup. We've got legal permanent residency or the green card. Green card immigrant visa means the same thing. Green card is really the holy grail of our immigration system. It can take, as short as 1 year, 1 year to 18 months to get it is about the fastest way you can get a green card, which would be through marriage to a U.S. citizen. Depending on the country of origin and the manner in which it is being pursued, a green card can take 10 years or more to get. So very often you've got somebody who's on a non-immigrant visa, and they might hold that status for several years before they are able to get to the green card. The green card allows for unrestricted work and travel authorization. The non-immigrant visa categories, those that allow for employment, are going to be employer and employment specific. So just because you have a visa authorizing employment for company A, it doesn't allow free work authorization or economic activity like the green card does. So the green card is where we want to get, where we don't have, where we're not tied to any one employer or to any one job. Or with a green card, you could not work at all. U.S. citizenship would be the third category. After you have had a green card for at least 5 years, you can apply to become a U.S. citizen. Obviously, U.S. citizen is also obtained by birth, being born in the U.S. or born abroad to U.S. citizen parents. So typically we're starting at the bottom here at non-immigrant visas and working our way up. So the non-immigrant visa categories we'll talk about first, and we mentioned that there's different eligibility criteria, different purposes. Temporary versus dual intent is an important element of the temporary visa categories that we have. Some require temporary intent, meaning the individual who holds that visa or is applying for the visa must have the intent to return home. The biggest examples of this are going to be the visitor visas, student visas, and some visas that allow for employment, like the TN, which is for Canadian and Mexican nationals. So if applying for this visa, the officer at the consulate or a CBP officer at the port of entry, like the airport, does not believe that the person is going to return home and cannot show ties to their home country, they will not be admitted to the U.S. So it could be possible to get a visa issued from a consulate but not be admitted by the CBP officer at the airport because of this temporary intent requirement. Also adds an additional complication to pursue a green card. Temporary intent has the requirement of the intent to go back home. Pursuit of a green card, it would be an obvious showing of an intent to immigrate to the U.S. So it can be difficult to jump from a visa category that requires temporary intent to a green card. If we can, we'd like to move to a visa category that allows for dual intent. Dual intent meaning, while it's a temporary visa, you may have the intention of pursuing a green card or immigrating permanently to the U.S. Some of the visa category, all of these visa categories are going to allow for dependent family members, meaning kids under 21 and spouse, to accompany the principal visa holder to the U.S. A select few of the visa categories will allow for employment authorization for the spouse, and it will be unrestricted employment authorization, even less restricted than the principal's authorization, which is going to be tied to a particular employer. So these visa categories have different procedures, different processing times. So if you're talking with a client who's going to pursue an E2 visa or a TN visa, just know that those processing times can differ. And if that's going to be a factor in closing or to get the transaction done, you'll want to take those into account and discuss that with your client. You know, what is the visa category you're pursuing? What is the anticipated time frame that we're working under? all of these visa categories, and really any immigration status period, is going to allow for the purchase of property, for the purchase of real estate, for real estate investment. There's none of these visa categories or the immigration status that we have prohibits real estate investment. In theory, an investor could have no legal authorization in the U.S. at all, and they may purchase property. The difference is employment allowed? Are they allowed to work? So you might see foreign national investors legally invest in U.S. property who have no legal authorization to work. That is permissible, just like they could own stock in the stock market. If they are not working, that's fine. A passive investment could be permissible. So we'll talk about some of these visa categories, and starting with the business visitor category called B1, and that's a great example. So one in the article that was in the first slide, I believe it was in that article, or it was another one that I've seen recently, is that a common challenge is a foreign national investor, particularly an individual, may not have a network of individuals to come over to the U.S. to view a property, to acquire, to manage the property. Well, they could have a difficult time doing that depending on where they're coming from. So a B1, B2 visitor visa, B2 is for pleasure visits, B1 is for business visits. B1 allows for certain permissible activities that can be, again, business or economic based, but do not rise to the level of employment. So a B1 cannot work. You can come over for 180 days and go through certain business-related activity, like look at property, consider an investment, perhaps form an entity, meet with a broker. Those are permissible B1 activities, but they could not manage that property once it's acquired, because that would go beyond what is permissible for a B1 and would go into the area of work. So again, if you've got 180 days to come over and look at property, to come over and check on property, it's permissible to do that. It is harder from some countries than others to get a B1 or a B2. That is applied for directly at a consulate. It is a strict temporary intent category, and it is highly discretionary. You know, the person applying for that visa is going to have about 2 minutes at an officer's window at a consulate, and the officer has the discretion to say, no, I don't think you're going to come back, or I think you're going to work. So they can, in their discretion, deny a visa application for a visitor on that basis. Versus a person coming over from Canada, for example. Canadians, for most of these categories, are visa exempt. They don't have to go to a consulate and get a visa. They don't have to go through that exercise. They get on a plane and come over, and the scrutiny that they face is going to be from the CBP officer at the airport. Same laws apply, the same standard applies, but there is less scrutiny. There's not a two-step process for that person to be able to come to the U.S. So think of that as you have clients who come back and forth, who don't live in the U.S., who don't work in the U.S. permanently, but are coming to check on properties. That is permissible to do as a B1. F1 or yes.
Can they sell real estate as well as buy it? Are those two things the same?
They are the same. Okay. Yes. So as long as on this category, for the visitor visa category, passive investment is permissible. Active management would not be. So if we're talking about somebody who wants to be in the U.S. on a longer term basis, or be more involved in that investment, in the management of it, we'd want to look at one of these other visa categories that allows for employment. Okay. F1 students, and the reason why I would even mention that here is because we see so much of foreign national students whose parents want to make an investment on their behalf, or the student, they want to make a gift or a loan to a student, and perhaps with an immigration component added into that. They want to pursue a visa through investment, or they want to pursue a green card through investment. So F1 students is what we'd be talking about there. H1B is the most commonly used visa category that we have. It's for specialty occupation workers, meaning any position that requires at least a U.S. bachelor's degree or the equivalent. And this is, of these, the most commonly heard, written about, at least in the news visa category that we have, largely because it is subject to a yearly cap. The government only issues 85,000 of those each year. And for the past several years, the economy is doing well, hiring is up. Well, the H-1B goes along with that. And so the cap for the H-1B visa category has been reached every year for the past several years. This year, there were 199,000 applications submitted for the 85,000 available. Years prior to that, the year before it was 233. The year before that, it was 236. So you're talking about a 30 to 50% chance of getting one of these visas, depending on the luck of the applicant. And the filing period is in April. The visas themselves, the H-1B visas, are released in October when the fiscal year begins. So there's a filing period 6 months in advance of that. And the USCIS, when there is an excess of applications, as there was this year, they conduct a lottery. It is a random lottery, has nothing to do with the merits of the application. They aren't even looking at the contents of the application. And we are now in the result period of that lottery, even though it's middle of June, and the filing period was the first week of April. We will start getting the rejections. So if you're not selected in the lottery, the government sends the whole package back to you with the filing fees. And then for those who are not selected, we really start looking at any of these other categories. Are there any other categories that could be applicable for the individual? And many times there's not. So a foreign national might really want to consider options through investment, real estate, or anything else. L1 is an intercompany transferee. Think of companies that have multinational presences here. So if an individual works abroad for at least a year in a managerial or executive role, and they're going to be transferred to the U.S. to also work in a managerial or specialized knowledge type role, then the L1 category is what we would use. The E2 treaty investor, I think, is the one that you guys would be most concerned with for real estate investors. So it says treaty investors because there must be a treaty between the U.S. and the foreign national's country of citizenship, not country of birth. So we do see sometimes where a foreign national is born in a country that does not have an E2 treaty, like China, like Brazil, like India. These countries cannot use the E2 visa, but if an individual becomes a citizen of another country that does, like Canada, then the E2 becomes an option. The E2 is not for passive investment. So if you've got somebody who's coming to invest in a real estate venture in the U.S. and they have no desire to live in the U.S. or manage that operation physically in the U.S., then the B1 might be fine. They might be fine coming back and forth on a sporadic basis to check in on the investment, attend meetings, look at other opportunities, etc. But if the person desires to live in the U.S. and actively manage that investment, then we would look at the treaty investor, the E2 temporary version. The E2 requires a substantial investment, but substantial is a term in our immigration law in this context that is not defined by a dollar amount. So it's not like the EB5 category that we'll talk about in a few minutes. The E2 requires the amount necessary to get that type of business up and running. It must also meet marginality and proportionality requirements for the E2 category. Marginality meaning the investment is going to provide economic opportunity and employment opportunity for people other than the E2 investor and his or her family. So we need employment here. We need either direct employees, or in real estate ventures, we often are using indirect workers, because you've got accountants, you've got marketing people, you've got maintenance people. You might not employ them directly, but the investor, if through contract, is providing economic and employment opportunity for other folks, then we factor that into an E2 application. So again, treaty-based, substantial investment. The proportionality element means the higher the investment amount, the lower the percentage could be of the individual investor's infusion of capital. The lower the total investment amount, the higher the percentage of investment must come from the individual. For example, if a person is going to come over and invest in a real estate opportunity that is a $10 million investment, that individual might be fine on an E2 application only personally investing 10%, because $1 million would still be considered a substantial amount. If the investment is only $100,000, then we would expect the E2 investor to invest 100% of that. If they're only putting in 50% of a $100,000 investment, the adjudicating officer at the consulate is going to give them a problem on that proportionality requirement for the E2. So there's not a specific dollar amount, there's not a specific number of employees that we need to have for the E2. All of these visa categories have a limit, or rather some of them do. The H1 can only be used for 6 years. The L1 can only be used for 7. The E2 can be renewed indefinitely. So you can renew an E2 2 years after 2 years after 2 years. That's the maximum validity period that you will get on the authorized stay for an E2. But each time the E2 status is renewed, the applicant must show that there is the continued sustained investment. So it's not a one-time make the investment, take your money and run. You've got to show the continued growth. If you started and got your E2 the first time and you had 5 employees and business has gone south and everybody was terminated, that's going to be a difficult type of visa to renew. So we want to show at least maintenance of economic opportunity for other people, and ideally we'd want to show growth. O1 is for extraordinary ability, so it can be used in any field. Some of you are, I see, in Arlington, so several of the Rangers could, and even this year, several of the Rangers could use this category despite it being a little bit of a down year in Arlington. And I can say that with love because I'm from there. But extraordinary ability can be used in the arts, athletics, science, business, you name it. The standard there is top 10% of the field of endeavor, however we define it. And when we talk about looking at other categories because we run out of options, with the H-1B cap being the biggest example, when a H-1B lottery loser, I'll call it, is looking at other options, people start looking really extraordinary. You know, and we need to show to the government, hey, this person really belongs, deserves to stay here under the O1 extraordinary ability category if that's the route that we need to go. We talked about how the E2 is a treaty-based visa, country-specific visas, and we have a few others. The TN, the H-1B1, and the E3. These are all quite similar to the H-1B. So these are going to be for professional workers. The TN is stands for Trade NAFTA. It's for Canadian and Mexican nationals only. And it is similar to the H-1B in that it's for professional workers, except it's only for a finite list of occupational classifications. The H-1B could be broadly used for any position that requires a bachelor's degree. The TN has a specific list of jobs that can be used, again, only for Canadian and Mexican nationals. This is an example where country of origin is not the determining factor, rather citizenship. So a person could be born in another country, become a citizen of Canada or Mexico, and the TN becomes an option. It does not have a cap, so it's a great option when we can't do an H-1B. And it's on the, we talk about political factors weighing in, it's on the chopping block perhaps. We've heard the Trump administration take aim at certain trade agreements, including NAFTA. Well, if NAFTA goes away, then the TN could go away as well. So you've got a bunch of folks here on this visa category that are going to be scrambling, looking around for other options. The H-1B1 is only available for nationals of Chile and Singapore, very similar to the H-1B. It has its own cap, but it never gets reached. So when we find somebody from one of those two countries, we're really excited. The E3 is very similar as well. It's only available for citizens of Australia. Immigrant visa or green card options through employment is where we'll spend most of our time. But again, this is where we want to be. This is a longer term project to get a green card. There are different family-based categories, but the only one, again, with current administration taking aim at family-based immigration, which kind of gets called chain migration sometimes. Chain migration is not a term that exists in the law, but it's used in the political arena more. But it's really referring to family-based immigration. the only way to really immigrate through the family-based categories within any type of reasonable time frame is through immediate relative U.S. citizen sponsorship. Immediate relative meaning a spouse or a child who's over the age of 21. That process right now takes about a year and a half, depending on where you are in the country. The most remote or further down the totem pole is a U.S. citizen adult sponsoring a foreign national sibling. That is an available category, but you're talking about a 20-year wait. So in reality, it is not used very much. What we see the vast majority of the time through family-based immigration is going to be through immediate relative marriage to a U.S. citizen or a U.S. citizen child who's over the age of 21. A foreign national does not benefit immigration-wise. They may benefit in many other ways in their life, but they do not benefit immigration-wise from a U.S. citizen child who's under the age of 21. They cannot sponsor a parent until they become at least 21 years of age. These other categories mentioned, these other bullets, are the employment-based categories, which is where we live in our practice more often. The EB-1, extraordinary ability, we talked about the O-1 temporary visa and the L-1 for multinational executives. Those fall under the EB-1 category. It is a relative shortcut to get a green card through one of those categories. You're talking about a very small percentage of folks who pursue the green card through this way, but it is a faster way to get a green card than what most folks have to go through. Faster being a relative term, you're talking still about 18 months, maybe longer. As a general rule of thumb is that all of our processing times are taking longer these days than they did 2 years ago. Most folks have to go through the EB2 or EB3 categories. These are going to require employment sponsorship. So this is a company willing to go through a process that's going to take a long time, that's going to be fairly expensive, where they show that they were unable to find a U.S. worker for the position. And then the foreign national will pursue a green card through a 3-step process. And then $500,000 investment at a minimum is the EB5 category. So this is kind of the older sibling of the E2 that we spent some time on. The E2, remember, being the temporary visa category for investors. Remember also that the E2 had some elements that do not exist for the EB5. Number one, the E2 was restricted to certain countries that have a treaty. Okay, the EB5 does not. The EB5 category is not a treaty-based category. It can be used by nationals of any country. Remember also that the E2 did not have a specific dollar amount, did not have a specific number of employees that were required. The EB5 category has bright line tests for both of those. So the general rule on EB5 is that you must invest at least $1 million in a new commercial enterprise. That amount is lowered to $500,000 if the investment is in a targeted employment area. The targeted employment area is an area of high unemployment or a rural area. The investor must create at least 10 jobs. So if it's a direct investment, that means direct hires. That means W-2 employees that we've got to show that have been hired by that enterprise. If it's a regional center, which we'll touch on in just a second, those jobs can be direct, they can be indirect, they can be induced. The EB5, among the things that we've talked about today and we'll finish on, is one of the most newsworthy categories that we have. It's been around since 1990. These dollar amounts haven't changed, and it's always been a fairly quiet category for us. Now, in 2008, 2009, when banks stopped lending money, we had the financial crisis in the U.S. You had, among other interests, real estate developers looking to raise capital and couldn't get it from banks. The EB5 category got very popular. So the EB5 category has been around, somewhat underused, really grew in popularity about 10 years ago and has continued to be pretty strong. It's a temporary legal program, but it has been extended over the years in short increments. Over the past 2 years, those increments have become very, very short because it's been the subject of political discussion and possible ending of the entire program or changes to the program. The current extension that we have is good until September 30th, 2018. the government tells us that we should expect changes to the program. Those changes would include an increase in the minimum investment amount. All kinds of speculation of what it could go to. It's $500,000 now and $1 million now. We've been told it could go to 800 and 1.2 or 1.2 and 1.6. We just don't know. But bottom line is, if you've got a client who is considering the EB5 category, they need to get while the getting's good, because those dollar amounts are set now. We've got this imminent expiration date of just a few months away. And they may extend it again. They've kind of made this threat for a couple of years ongoing now that we should expect changes to the investment amount, and we haven't seen it yet. So the differences on this slide, we talked about regional center versus direct investment. So direct investment means foreign national comes in and invests in their own business, starts their own business. The capital goes in for the benefit of that entity, and they are directly hiring 10 U.S. workers. The vast majority of EB5 investors do so through what's called a regional center. So this is an entity that is applied to the USCIS to be approved to engage in some economic activity within a geographic area. And through this, they have demonstrated to the USCIS that at least 10 jobs will result for each investment unit. So this is a very common way for real estate developers to include foreign national capital within their capital stack. They might have their own equity, they may get conventional lending from a bank, and then they might have EB5 money in there as well. So this is more of a passive investment versus the direct investment option of the EB5 category. Foreign national puts in $500,000. Most of these are set up in TEAs, just because they find that it's easier to raise money at $500,000 a pop versus $1 million. So, I'm here in Dallas, and there are regional center real estate projects all around town. And they may look to not be rural. They're certainly not rural areas, but the regional center is often able to get them designated as high unemployment areas, as they do that by piecing census tracts together. It allows them to raise money at $500,000 per investor, provided that they can show through an economic impact study, typically done by an economist, that at least 10 jobs will result per investor. So direct hires, indirect, or induced. And this is far and away the way that most folks go. And part of that is a consequence of the EB5 market has largely been driven by Chinese nationals. And remember that they can't use the temporary E2 version. So they are waiting in China for the green card process to be completed. Whereas an individual from Canada, Mexico, any other E2 country, they might come over to the US on a TN visa, on an E2. They've got more options to live in the US permanently, to relocate the family here while they're going through the lengthy EB5 process. So EB5 investors being from China are not really able to oversee the investment. It needs to be more of a passive investment, so the regional center model makes more sense to those investors. And I should also mention that the advantages of the EB5 category are not quite what they were. So it was attractive for foreign nationals who would normally have to wait a really, really long time to get a green card. The green card categories that we showed a few slides ago are all subject to a quota system. And no one country can use up more than a certain percentage of the green cards allowed under each category. When they use up that percentage, a backlog results. So the EB2 and EB categories had long waits for certain countries, most prominently China and India. So Chinese nationals not being able to use the E2, facing long backlogs in the other categories, really flocked to the EB5 category because it was so much faster. Well, with the growth that we've had in the EB5 category, we now have backlogs in the EB5 category as well, right now only for China. And if you look at the Department of State Visa Bulletin, which keeps up with such things, and it comes out every month, it'll tell you what the wait is. If you looked at it today, it would look like only about, I say only, but it would look like only about a 4-year wait for Chinese nationals. In reality, that may stretch out to 10 years really quickly. So what was a significant part of the EB5 category being attractive to Chinese nationals is not really the case anymore. It still is. The timing can still be preferable for nationals of other country, but not so much China. And remember, they don't have the temporary E2 that they can use to come over while they're waiting through that long processing time. And Amy, I'll start. Did we have any questions? I'm not sure if any were popping up or not.
I do have some. They didn't seem to be specifically about the topics you're addressing, so I've kind of been waiting for you to start a new segment. So if you want, we can go back and talk about some of those.
Why don't we do that? Because the next few slides are that's kind of the end of the employment-based categories that we were going to talk about. So let's see what you've got so far.
Okay, so someone here says that they are focused on residential purchase with the NATO 1 and NATO 2 visas. All the banks in the Wichita Falls area can't get approval through underwriting. One big reason is because of no credit history. How can I get them qualified?
What was the type of the visa that they said?
It says NATO 1 and NATO 2. Claudette, if you wanted to put in a little bit more information, it might be helpful. And I'll move to the next question while she maybe types something in. So this next question is about dreamers and deferred action, so I'm going to hold off because that seems like it's coming up. Someone said,
that's the next slide.
I live in El Paso, and sometimes we encounter parents who have their sons or daughters at the university and want to buy a house for the kids to live in. And then he typed, can they pursue another visa for business or employment?
Okay, let's go on that one for a little bit. So yeah, we talked about it's quite common for foreign national students to be here on the F1, and mom and or dad want to buy a house for them to live in. That house could, in theory, be in either one of their names, even if from an immigration standpoint. I understand there could be other challenges like title, but from an immigration standpoint, it would be permitted for that house to be purchased by parents who do not live in the U.S. or by the student. So these are things that will need to be discussed with the title company. You know, be clear with them about who the buyer is, who's going to be the resident in the house. But the immigration laws that we have would allow for either of those purchases to happen by either the parent or the student.
Okay, interesting. Can an EB5 applicant legally add family member, spouse, and kids on just one 500,000 investment unit? Yes.
So any of those green card categories, including EB5, includes dependent family members. So you can bring spouse and you can bring dependent children who are under the age of 21. We just talked about the backlog that has resulted for China. So if it is from a non-backlogged country, the EB5 process, if it goes very, very well, takes about 2 years to get a green card from the time that the first application is submitted. So what happens when a child ages out during those 2 years? If it's from a non-backlogged country, meaning not China right now, then the child's age is frozen at the time that the first EB5 petition is filed. So, you know, I had that not too long ago with a family from South Africa. We literally filed the EB5 petition when their oldest child was about a week away from turning 21. Now, the child was well over 21 by the time the family all received their green cards, but she was included because of what's called the Child Status Protection Act. Freezes the age of the child. It is more complicated when there is a backlogged country. You have to do this formula of what was the child's age when it was filed. If over 21, they're out of the picture for sure. But if they were under 21 when it was filed, and then there was a backlog, then you look at how long the petition was pending versus how long was the wait for the visa to become available. Right now, it would be virtually impossible to ever guarantee a child from China is going to be included as a dependent, just because we don't know what the visa bulletin and what that wait is going to be. So short story is yes, the children and spouses are included for one investment, just one investment. They're included as dependent family members, but the definition of a child varies.
Okay. Phew, that's super complicated. I had some follow-up on that original question. Claudette says, Wichita Falls has the largest NATO base in the United States, and
Oh, okay.
NATO pilot on NATO visas wanting to purchase a home since the rental market's not good. So
yeah, and that's not really specific to a visa category. I understand it would be in the question, but that's going to be a closing challenge for any type of temporary visa category that we're looking at. And we'll talk about a few of those other examples in a minute, which is more on the residential side than what we had included in the slides from some other talks that we've done. But yeah, the bottom line is the law will allow that person, the immigration law will allow that person to purchase a home. But are there going to be some closing challenges because they don't have U.S. credit history, because they may not have a Social Security number yet, depending on how long it is they've held that visa. They may not have a driver's license yet. So talking to the title company is what you would need to do to try to overcome some of those hurdles. But bottom line is the immigration law would allow for the purchase of a home in that scenario.
Okay, I have a related question here that says, I'm a real estate investments broker specializing in assisting foreign nationals. I've helped many clients applying for visa with their immigration attorney. Now the challenge I am facing, aside from the visa application, is that banks are reluctant to open accounts for such clients while the consulate is requesting accounts in order to prove the business or investment's existence. Please provide suggestions on how to tackle this issue. This might be a similar answer as the last question.
It is, and unfortunately we run into that issue pretty frequently. And what I have learned is to shop banks. You'll have some banks that will accept certain documentation for purposes of opening an account. Some banks that are international in scope are more likely to open a U.S. account if they have a branch abroad, perhaps where the client had an account open. We just had this recently on it was an intercompany transferee case, so the company was looking to open an account here in the U.S., but they had no company officer here yet, and we had been told from a bank that they'd be able to do it by getting an ITIN number. So foreign national could not get you can't get a Social Security number in the U.S. now unless you have work authorization. But a foreign national can get an individual taxpayer identification number, which is issued by the IRS. It is used in lieu of a Social Security number in many respects, including opening a bank account. So, talking to different banks is the best approach I have to that, and some are just more flexible than others.
Do you know if those sorts of things you can start that application process before you get to the States, or can you not do that until you get here?
Well, it sounds like the question kind of contemplated an E-2 application. So a consulate might be looking for documentation from a business to show that it's real and operating. An E-2 business cannot be purely prospective. So a consulate might be looking for that type of documentation. So we run into a chicken and the egg situation all the time.
Okay.
And this is where we use this B1 category. The B1 business visitor allows for some of the provisions of the law that allows for B1 usage are very broad, and some are very specific, like race car drivers or professional golfers or people coming over to give a sermon. It also provides for activities in anticipation of submitting an E-2 application, like making a purchase, like renting the physical premises where the business will be located, forming the entity, opening the bank account. So we will sometimes benefit from having a U.S. citizen or somebody here in the U.S. as a partner. They can be named named on the account, named in the company formation documents, and they can do some of that work instead of the foreign national being here. So they can get the account open. If that is not feasible, which it often needs to be, it's usually just the easiest path to go is to have a partner in the U.S. who can go through some of those steps for you. Then you really, if not, you can really get into a pickle if there is no person in the U.S. and the person can't get over here because maybe they can't get issued a B1 because they're from a country that's more difficult about it. it's going to be more challenging. So doing what you can on the B1, if that's an option. If not, having a partner in the U.S. to go through some of those steps can smooth a lot of that over.
All right. Someone
Okay.
asks, the EB2 investment money come into the U.S. available for, I'm sorry, I'm not sure I understand this, but I'm going to go for it. The EB2 investment money comes into the U.S. available for investment first before the green card is issued, or does the fund for purchase of personal real estate property for EB2 applicant come in included in the $500,000 investment? Oh, I see. So I think what this person is asking is if they were investing in a business but also wanted to buy a house, would the cost of the house be included in that investment for the visa purposes?
Okay, I hear three questions there, or three issues. Number one, the investment made into a house would not be considered as part of the E2 or EB5 investment. It's not a business. Now, if you were purchasing a bunch of houses and you were managing them under a real estate management company, then perhaps. But if it's just a personal residence, then no, that would not be included in either an E2 the temporary, or EB5 the permanent. The other question I heard there, I think, is with respect to timing. When is the investment made and when is the application made? The investment has to be made. This is not, neither of these can be a prospective, you give me the visa and I'm going to start this business, or you give me the visa and then I'm going to start this and I'm going to make this investment. For an E2, the trend has really moved towards the business needing to be real and operating. So talk about a chicken and the egg problem. How are you supposed to come over and run your business if you can't get an E2 first? Well, we need to do as much as we can on the B1, or we need a partner in the U.S. But we have to make the investment. The money has to have moved over from the foreign nationals account in their home country to the U.S. account. And not only must the money has moved, we want that money to be committed. Committed meaning spent. Not all of it, but we need to start to show the bank account history. An E2 application has to include evidence of the transfer of that money and how the money's been used. Have we hired anybody? Have we purchased equipment? Have we rented office space? So you'll want that included on E2. EB5 is the same thing. The money has to be moved over before you could make a viable EB5 application. Now, in an EB5, because it's more of a long-term project that we're often looking at, we, especially through a regional center investment, we usually see the money go into escrow for some period of time. So the money goes over, $500,000 goes over into escrow, and then there is some trigger for that money to be released. That's going to depend on what the regional center's model is. It used to be they would wait until the petition was approved, but as processing times got worse and worse, that was not practical for them to have all the money just sitting around doing nothing, waiting a year for these things to be approved. So now more regional centers say it's going to go into escrow until your petition is filed and we get a receipt notice, or until the first person in that fund has a petition approved. But either way, we've got to have the money sent over before we're able to submit a viable application.
Okay. All right, I'm gonna suggest that we move on to your next section because it's getting late and I want to make sure you get through everything, and then if we have time, we'll come back and we'll tackle some more questions.
Okay, and I'll be quick on these. I wanted to mention these. They're more in the residential context, but some of these other categories that fall out of the more conventional categories that we've discussed. These aren't the temporary visa categories. These aren't the more conventional ways to pursue a green card. DACA, Deferred Action for Childhood Arrivals, Dreamers, it's all referring to the same thing. Because of the government's inability to address folks who come over here as youngsters, typically brought over by their parents and go to school here, and then they have no status, can't get a job, can't get authorization to work. In 2012, the Obama administration had this executive order for deferred action for childhood arrivals. Those who came over before a certain age, either were in school or graduated, they were able to get, and this was supposed to be a Band-Aid until there was a larger legislative fix, but it didn't allow for a status the same way a green card or a temporary visa status is. It was a temporary statement by the government saying, we're not going to deport you. Here's your work authorization if you meet this criteria and you haven't committed any crimes. So the program was set to end earlier this year, and it's in litigation, and it's on life support. But this is, I can't remember what the final number is of how many applicants that they have currently under this program, some of which are able to transition to another longer term solution. Maybe they've since gotten married to a U.S. citizen and they can pursue a green card that way. Depending on what their immigration history is, sometimes there's a path from DACA to something else. But for a good chunk of them, there's not. And that's why this is such a big deal. If this program goes away, then many of these folks are going to have no way to stay here legally. Many of them have been here for a long time. Their families have been here a long time. They own homes. So we're all kind of just waiting and seeing how that plays out. Similar category is temporary protected status, TPS. TPS is granted, hence the name, on a temporary basis for countries who are going through some type of environmental or armed conflict or environmental disaster. So there were 10 countries that currently have it, but the administration has announced that it will be ending for 6 countries. So El Salvador and Honduras. So of the folks granted TPS status, about 98% of those are set to end. So same considerations as with DACA. Sometimes those folks are able to transition into something more permanent depending on their individual circumstances. Sometimes they are not. So these are folks who in many cases have been here for a long time and will be looking for other options, but they're going to be very limited. We talked about this real briefly. Driver's license and social security number issues. You must have work authorization to get a social. So even dependent spouses and children, those who are here on a dependent visa, a temporary dependent visa, they have legal authorization to physically be in the U.S. They can attend school, but they can't get social security numbers until they have work authorization. Lawful presence on driver's license issuance varies by state. Some states have no requirements that you show that you're here with any type of status. Texas has gotten into the immigration game. Texas DPS has as of several years ago. So you have to show lawful status in the U.S., not necessarily a social security number, but that you have, and this can be challenging because they're not immigration officers, and there are many different documents that can be provided. Their website has a list, but we frequently see this where our clients go in to renew their driver's license, and I know they're here legally, I know they have work authorization, but it's hard to convince the DPS of that sometimes. But you do have to show lawful presence to get a driver's license in the U.S. And for some of those title issues, in lieu of a social security number, we talked about getting an ITIN, which you can get regardless of status, regardless of work authorization. If you can't get a state ID in Texas, then some consulates or some banks, some title companies may consider accepting a matricular consular card or a foreign issued ID. If not, then one possible workaround is to get a power of attorney. For example, if you need to sell property and perhaps a recent deportation prevents you from being physically in the U.S. and able to do that. So, in both a real estate and commercial context, those are some of the takeaways that we want you to think about. Talk about this early on with your client. If you have the type of relationship where you know that immigration is an issue in their life, you'll want to address those, identify those issues early in the transaction and not closer to closing. Think about the timing issues. A TN is not the same thing as an H-1B. Everything is going to be different in terms of processing times. And you'll want to take that into account so it doesn't disrupt your transaction. So those were the additional issues that kind of overlap between residential and commercial, but that's kind of all I've got, Amy, unless you've got some other questions queued up.
I do, and I actually have a question. If heaven forfend, someone's visa status expired in mid-deal, then what happens?
Right. So we always can consider the option of a bridge or a slight extension for wrapping up affairs. So as a hypothetical, we talked about the H-1B visa category can be used for 6 years. So let's say the person is at the end of those 6 years and they can't extend it anymore. They don't have any other work visa category that is applicable. We would file in that case to change to a visitor, to a B1, just for purposes of wrapping up affairs, moving out, selling a house, whatever it is. That will only, at the maximum, buy them another 6 months, because the B1 can only be used for 6 months maximum. In reality, we don't even care if it's approved. The filing of the application protects that person's status. They're still, quote unquote, in legal status while the USCIS adjudicates that application, and their processing times on that are going to be close to 6 months anyway. So even if they deny it, hopefully we've accomplished what we needed to accomplish by buying a little more time, and they've gone since then anyway.
All right. So the secret is keep an application at the ready.
Yes.
All right. I'm going to go back to a question someone asked earlier that says, under the deferred action law, I had a case where a title company held 30% to send to the IRS. Is that what you would see? Also, some issues being able to obtain a loan.
Mm-hmm.
Is there any information could help us handle that better? She asks.
I'm sorry, but not really. On that 30%, I have seen that, and I kick that over to an accountant colleague because that gets into tax issues and outside my area. But yes, and so, it's another communication with the title issue on. But I have seen that holdback happen, and I'd want to talk to a CPA or a tax attorney if that were my client and see if that's something that the title company was entitled to do in that scenario. But what was the second one?
Sorry, I just clicked off the question. And it's already fallen through. Sorry, obtaining a loan. That was it. Having trouble getting a loan.
Yeah, same thing. And I get to be in the position frequently to talk with title companies or to talk to lenders because they aren't familiar with some of these categories. And so I have this quite a bit. Hopefully your client has an immigration attorney who can help with that communication, and it can be helpful. It's not 100% effective, but I see it work a big chunk of the time where it is just unfamiliarity with the lingo and with what the categories are. And a recent example I had where I had a client who was applying for a green card through marriage, but she had been legally here on a TN work visa. She was a Canadian national who happened to be an attorney. Well, the consulate, she's got a green card application pending. She's got a temporary work permit that was issued on the basis of that application. She's got an expired, or no, she had a still valid TN, but the TN that a Canadian gets is not a physical visa. So the lender kept asking for a visa. And, she said, I have this, I have this, I have, which was everything but a visa. She had about 3 other documents that showed either work authorization or that she was legally authorized to work here. So, I have to write a letter explaining what these documents are, why she doesn't have a visa, why she couldn't get one even if she wanted to. They're not applicable for that category. So it's very often a terminology and a communication issue when you're dealing with the lender or with a title company.
I see. I have a few more questions here, but I think we did hit some of those earlier. Someone asked if EB applicants and family legally can work in the U.S. I believe that was a yes, right?
Okay, if they're talking about a green card category, like one of the employment-based or family-based green card categories, they will be able to work eventually. Once they receive the green card, of course they can. They'll have unrestricted work authorization. Up until that point, it's going to depend. When you apply for a green card in the U.S., you submit an application called an adjustment of status application that allows you to also apply for a temporary work permit. It takes a while to get to that point. So at the end game, yes, they'll have work authorization, and then they'll have work authorization at some point in the middle.
Okay. Someone asked which government agency determines and sets the type of jobs and investments in need for EB2 investments?
Who determines the types of jobs? What?
The types of jobs and investments needed for EB2 investments, I guess.
I assume they're referring to temporary E2, and So the E2 application is going to be adjudicated. If you file for it in the U.S., it's going to be adjudicated by the USCIS. If you file for you can also apply for an E2 directly at the consulate abroad. Every country that has the E2 has one consulate, sometimes more, but at least one that adjudicates E2s. It's kind of a specialized application that requires a specifically trained officer. That's who determine it. So it's either the DHS, the USCIS if it's here, or it's the Department of State by a consulate who's going to determine it. They're going to look at that factor. That's the marginality element, providing economic or employment opportunity to somebody other than the applicant and his or her dependent family. They're going to direct employees are preferable, but we would also show evidence of indirect workers via contract, like we touched on earlier, but that's who is going to factor that in, the officer adjudicating the application.
It's beginning to make sense why these things take so long.
Unfortunately, yes.
Wow. This is a review too. H-1B1 visas apply to whom again?
Chile and Singapore.
Chile and Singapore. That's a nice, neat answer. We like that. Oh dear, well, this might be. As a bonus, can you tell us if there is a law requiring the separation of children from parents? I think that's a different topic actually, because those are not people who have applied for visas yet. So that I don't think is something that somebody's actually going to see too much in a real estate business. Does anybody
that's a dangerous question too. That's you could find 5 different answers on 5 different 5 different websites if you want.
Hopefully no one we know is in that position. Does anybody in our classrooms have any more questions they want to throw up their hands and ask? Does anybody have, here it comes up again. The slides were really helpful. Yes, I will get the slideshow and I will post it on the TAR website and I'll tell you where. Just a minute, here's another question. Yes. Any more questions before I launch into our closing remarks? Doesn't look like it. All right, I just have a couple of things to run past you guys. Thanks a lot. Brent, thank you so much. This is such great information and we really, really appreciate you taking the time to do it. I know you're really, really busy. Someone's asking if you can post your contact info, which I will leave that up to you, Brent.
Sure. Happy to. And on the slides, that last slide has my email and has the website too, which has all the contact information also.
Great. Okay. So our next webinar is on July 17th, and we're going to be back at our regular 10 o'clock time slot at that time. This presentation is going to be by TAR member Heather Canopka-Chavez, and she's going to do a case study of the transaction that won the 2017 William C. Jennings Award for Commercial Transaction of the Year. And if you didn't read about her transaction in the Texas Realtor magazine a few months ago, you'll probably want to tune in for this. It was a great transaction. If you're interested in CE credit, same as today, you can call your local board and ask them to present the class. If they can't do that, we can help set up your office for a remote classroom. You can get hold of me or John Hauser to do that. I just want to say a couple of other announcements that are TAR business. The volunteer tool to sign up to volunteer for a committee is still live on our website for another week until June 29th. And online registration is also open for this year's Texas Realtors Conference, which is in San Antonio from September 7th through 11th. You can go to TexasRealtorsConference.com and register there. We hope that we see all of you there. Brent, I thank you so very, very much. This was really great. If you guys have more questions, you can shoot them to me and I can get them to Brent, or there's Brent's contact information. Again, I'll be posting this webinar on our YouTube channel and also on the TAR website. And you can find that by going to the events tools and looking in past webinars. There will be a link there.
Amy, is that Steve there at Metrotex in Dallas?
Is that Steve there?
Steve, did you pull the fire alarm?
I can't.
leaving, man. What can I do? You know, they all just decided it was done and left.
I thought you were trying to get everybody out, so you just pulled the fire alarm.
Lunch is ready.
I do that to you, Brent.
All right, everybody. Thanks again, Brent. Thanks, everybody.
All right, thank you.
We'll see you hopefully in San Antonio. Take care, everyone. Bye-bye.